Good afternoon. Good afternoon. Inna, can you hear and see us? Is everything okay? Yes, I can see and hear you. I'm very happy to see you. Welcome to stage 2 of the selection to be appointed as members of HQCJ. So participating in your today's interview are all of the commissioners. I will briefly introduce them. These are Tedros Zhachny, Ivan Mishchenko, Stephen Markman, Robert Brueggeisen, Yevhen Mezintsev, and Sergei Varlanov. The rapporteurs for your interview are going to be Stephen Markman and me, Ivan Mishchenko. But before we start, some technical aspects that we have to discuss. If for some reason the broadcast is interrupted, should it be an air raid alert or power out or lack of internet connection, the Commission will get in touch with you and will resume the interview on a different day and at a different time, starting from the point where we stopped. As far as the interview itself is concerned, a commissioner that will be asking a question has the right to limit the duration of your answer. And before we start the interview itself, you will be given a chance to tell us a little bit more about your motivation to participate in this selection, to present us with your ideas. So these are the most important things that you would like for us to know about you. I'm now passing the floor to Judge Stephen Markman. Stephen, you're welcome.
And thank you, Ms. Bernaziuk, for your participation. We appreciate that and look forward to our discussions today. As my colleague, Judge Mishchenko, just indicated, we'd like to afford, can you hear me well? Are you there?
Sure, it's freezing.
I can hear you, but there are some interruptions. There is a lag.
You can hear me well, though?
Yes, I can hear you well now, but I didn't hear you before that.
Okay. Well, we don't have a perfect system set up yet, so please be patient with us. As my colleague, Judge Mishchenko, indicated, we would like to give you a chance to offer some of your thoughts at the outset, and then we will begin our questioning. But once again, we appreciate your participation in the competition, and we'd like to afford you up to 5 minutes to share your motivations for participating in this procedure or emphasizing anything else that you think is warranted. I would introduce you only to say at this point that you've had a distinguished career as a specialist in the Ministry of Justice, as chief economist for the National Bank of Ukraine, as a professor, and now as a representative of the Ombudsman Office for the Commissioner for Human Rights. Will you please proceed with your opening statement? Thank you.
Good afternoon once again. Good afternoon, dear commissioners. Good afternoon to the audience. I would like to use this opportunity to express my gratitude to the armed forces of Ukraine and to the citizens of Ukraine for their resilience in the fight for the sovereign, independent Ukraine. And we are also thankful to our international partners for supporting us during this difficult time. We understand this is not a war between two countries. It's a war of authoritarianism against democracy. So we are fighting for the opportunity to build a country where the rights of all the citizens are protected, the courts are fair and independent. We want to insert the choice of the people of Ukraine made during the Revolution of Dignity. And we want to do everything for Ukraine to join the European Union in the near future. It's a task for all of us, and it's one of the motivations that I had before participating in this selection. I want to be a part of the reform of the judiciary. We need to prove that the rule of law is working and that justice is present in Ukraine. In my opinion, the way a person thinks determines the way a person acts. That's why sometimes it's not sufficient to have the right laws adopted. It's important how they're being enforced. That is why the people that are enforcing the law, the mandate of the state, determine how the reforms will take place and how these or that bodies will be purified. So taking into account my experience and the skills, I think I can contribute to being part of enforcing the mandate of the state. I understand that you have analyzed my autobiography and the other documents I have provided you with, but at the same time, let me tell you a little bit more about what I've been doing during my professional career, because there have been questions about my experience of working in the field of law. So let me tell you a little bit about the positions that I've occupied. So I have the general experience of working in the field of law of over 17 years. Which includes both academic work. I've been a lecturer and I've also been a public servant. As you've mentioned, I started out working for the State Tax Inspectorate in Obolon district. That was my first workplace. I was employed right after graduation, after I got my degree in law. I was appointed as a result of competition, and my main responsibilities were to represent the interests of the state in courts and to interact with the state executive service. Also, I had to provide explanations of the tax legislation to citizens. So that was indeed solely my legal experience. So I had to interpret the law to people. And I have provided all the documents about that to the Selection Commission. Also, I would like to mention my academic experience. So I started back in 2008. When I presented my thesis on the topic Constitutional and Legal Status of Strategic Acts. In 2018, I presented my doctoral thesis, Constitutional and Legal Status of Strategic Program Acts and the Mechanisms of Their Implementation. In this work, I tried to research the importance of the reform of the judiciary as an important element of the reform of all the program strategic acts, both of the parliament and the government. I used to be a professor at the Department of Constitutional Right of Tavria National University, Constitutional Law, and there I lectured in constitutional law and comparative law of foreign countries. I have 60 academic papers published. The majority of them have to do with the specifics of functioning of the Ukrainian judiciary and the judiciary of foreign countries, as well as participation of international organization in lawmaking of Ukraine, which proved to be quite effective. Since most recently I was dealing with the protection of personal data, I also have some papers published on this topic. Now I would like to tell you a little bit more about the work I've been doing at the National Bank of Ukraine. I transferred there after working at the Obolon Tax Inspectorate. And there I was involved in design of different norms of regulations. Since the National Bank of Ukraine is responsible for the function of methodological support of financial markets, very many laws and bylaws were developed at the National Bank of Ukraine, and I was invited to perform this function there. It's also necessary to mention my experience of working at the Ministry of Justice of Ukraine. So this experience helped me analyze different laws and regulations, because the Ministry of Justice provides opinions about draft laws that are being introduced into the Parliament and the Cabinet of Ministers. At the time, we were engaged in the reform of the territorial and administrative division, so I was part of that process, and I had to stay long hours at work. For all my life, I wanted to be part of something that would result in the prevalence of justice. I always wanted for the state bodies to follow the law, not to abuse their power. And that is why I've always felt this need to be a part of the most difficult processes.
I'm going to have to call you to an end pretty soon. We're going to go far over the introduction period. Do you want to summarize what you wanted to say further?
Well, I think, if to be brief, I will tell you a little bit about my work for NACP, because there I was involved in the work connected to the design of procedures for the inspection of tax declarations, and also the procedures for studying different situations where conflict of interest arises. And while working for the Central Elections Commission, I was analyzing the candidates that were admitted to the voting procedure. So, in summary, I would like to tell you that I have positive experience of working in the central government bodies. I have experience of working with large teams of people, and I have experience of studying different documents of different candidates applying for different positions. Thank you.
Okay, thank you very much for that introduction. Let me preface a few of the first questions I'm going to ask you by saying that the background that you've summarized today is an outstanding background. My questions will focus, though, on the issue of whether or not they reflect the kind of legal experience that seems to be required by the competition. And the question that I have to you really focuses upon the necessity of a legal degree for what you've done, the necessity of a legal degree for other people who are doing the same thing as you're doing, and the direct relevance that your experience would have for your work on the High Qualifications Commission. I think what's obviously most in question here, and I think you realize that, has to do with your position as a tax inspector, as a participant in the National Bank of Ukraine as a specialist, and as an economist at the National Bank of Ukraine. Once again, it's high-quality experience that you have there, but I'd like to hear further why you think that's legal experience of the sort that the law of Ukraine requires for members of the High Qualification Commission. I mean, a barber is not a lawyer, but a barber has to do legal things too. He must determine that his premises are sanitary and clean, and that they're safe, and that his license is in accord with the law, and that it's renewed in accordance with the law. So many professions do things in which they have to maintain some acknowledgement and recognition of the law. But nonetheless, is your experience with those three institutions legal experience? That's something we'll have to judge, and we'll only do that in judgment after hearing your further thoughts specifically on whether those constitute legal experience.
Thank you for the question. I would like to mention that when talking about my work at the State Tax Inspectorate, while working at the National Bank of Ukraine, I was trying to convey to you that I was dealing with law, but at the same time, I was an academic, so I was writing research. I was researching the norms of law. So I'm trying to tell you that while working on those positions that I've occupied, I was constantly enhancing my level of knowledge. And if we talk about the work for the High Qualifications Commission of Judges, I think that my most relevant experience will be that of working at NACP. And I got there right at the moment when the commission was being formed, and I got the most valuable experience there because 4 members were appointed when I came in. So the head of the secretariat and the head of staff were appointed at that time. And with this small team, we were forming both the NACP team. We were hiring people for the department that deals with the inspections of tax declarations, including declarations of judges who are undergoing qualification assessment.
But is it not true, Ms. Bernaziuk?
So we were hiring the team. And there was a great demand for this body to be set up, and we had to keep up the cooperation with the Public Council of Integrity. We had to admit to the competition, we had to admit the international experts to the competition, and there were questions about interference in the work of NACP.
Well, I'm not questioning your work at the NACP. I'm only asking whether you or any other tax inspector in Kyiv was ever required to be a lawyer. My understanding is that that was not a requirement for the position, and that you, in conjunction with all other tax inspectors there, joined that position without the obligation to have a law degree.
Thank you for the clarification. Well, there was a requirement to have a degree in law, and it's foreseen in the law on judiciary and the status of judges that the legal experience, we should start counting it from the moment of you getting a law degree. And I started working after I got my degree in law, and there was this requirement that I have a degree in law. And another proof for the position having specific requirements is that I was appointed as a result of independent competition. I've undergone competition, and there was a requirement there to have a degree in law.
Do we have any evidence of that? I think we've asked for that, and we haven't seen that. We've seen no statement that there was a need for a law degree. We have seen a statement after you left these positions that you did some legal work, and I don't quarrel with that, and I don't doubt that, but I wonder whether that's the same thing as the authorities indicating that a tax degree was required for that position and for others who are doing the same thing. Okay. Well, let me move on to another issue, if I might do that.
Well, thank you for the question. I have provided you with a copy of my employment record book, and there you will see that I was appointed as a result of competition. I have addressed the tax inspectorate, and they told me they don't have the copies of documents which indicate the requirements for the position because they keep them for 5 years only. So I don't have any documented evidence. It's just the employment record book that I have provided you with.
Let me ask another question on a different subject, and I know you're aware of this concern too, and I raise it, and I ask you respectfully if you'd share your best thoughts on this, but Obviously, your husband is a very accomplished individual as well. He sits on the Supreme Court of Ukraine. And there would obviously be natural conflicts given that you would be serving on the High Qualification Commission and you would be serving on that part of the Ukrainian judiciary that has direct appellate authority for many of the actions of the High Council of Justice and the High Qualifications Commission. You've indicated that his response to that would be a recusal or non-involvement in cases in which there was a conflict. My question to you specifically is, would he be recusing himself so frequently and so often from cases coming before his court that he would be uninvolved in the work of his court more than he would be involved in the work of this court? In other words, in exchange for getting a fine person like yourself on the High Qualifications Commission, we would be subtracting a good part of the effort and the work of your husband.
Thank you for the question. As you've mentioned already, there will be no legal issues in here because there's indeed the right to self-recusal, both for my husband, should he get any cases that have to do with the activities of HQCJ, and the same goes for me. Should there be any minimal doubts about the conflict of interest, I can also announce self-recusal should I be appointed. But the most important thing is that the cases are being distributed among the judges. My husband is not the only justice of the Supreme Court of Ukraine. I know that there are not too many cases that are being appealed. It should be mentioned that the previous HQCJ had very good indicators of candidates appealing something, saying that their rights were violated in the process of selection. I'm not saying that there weren't so many of such complaints, but still they are being distributed among the judges. And as far as I know, the Supreme Court of Ukraine has overcome the issue of high workload. That's why I think it will not be a problem.
Well, let me put aside the potential for a conflict of interest and ask you a related question, but not exactly the same question. Is it desirable for Ukraine, is it desirable for this reform process that we have a husband and wife, one of whom is on the highest court of the state and the other who is on the extraordinarily important selection body of Ukraine? Is that a good appearance? Is that a good appearance for Ukraine?
Thank you for the question. I don't see any bad messages for the society. Should two independent individuals with leadership qualities from the same family occupying such high positions, since we don't see any issues with the conflict of interest, we don't see any other potential challenges, we can also ask the same question: can we have two doctors of law in the same family, as it is with us? Because I'm also a doctor of law and my husband is a doctor of law. It's not a problem. And in the same way, my right at this very stage cannot be limited, my right to be selected and to be appointed. So does it mean that if my husband has been appointed as a judge, I'm limited in my career? Limited in my career in the judiciary? So the judiciary is one of the branches of the government, so it appears as if I cannot have a career in the judiciary. It would be bad if I were subordinate to my husband or he was subordinate to me, but these are two different independent bodies. And that's where the crux of the matter is. And it should also be mentioned that the judges that are appointed under the new procedure, should there not be any complaints, they are not supposed to undergo any qualification assessments in the near future. That's why I think an outsider should not have any additional questions, but still thank you for this question.
Let me move to another subject, a completely different subject, and it's perhaps of the greatest concern to me, apart from the question of whether you qualify for the commission in terms of having 15 years of legal experience, but it has to do with the question of the free land plots. And my understanding is that there are 2 free land plots that have been obtained in the Kyiv region, very select, very attractive part of Ukraine, 2 of those. There's another one that your husband owns in the Kyiv region, a free land plot. There are several free land plots that your father owns, I think principally in the Chernivtsi region, and I believe there's a free land plot that you also own in the Chernivtsi region. My question here is not too, it's related to the previous question about appearances. It's not a matter of law. I understand that you have registered these free land plots in accordance with the law, and you have received them in accordance with the law. So my question has nothing to do with you having violated the law. It has to do with the question of connections. It has to do with the kind of concern that I think has concerned many people who look at the Ukraine judiciary and wonder about its integrity. And that's the question I have here. Why do you have so many free land plots? Why have you thought that there's a need for so many land plots? Why have you qualified for these land plots? And what is the appearance that this communicates, again, to your fellow citizens of Ukraine?
Thank you for the question. As far as the land plots are concerned, you've mentioned that my father and I owned land plots where I was born. So I was born into a family that was quite rich at that time. As you can see from the documents that I have provided you with, my parents had lots of assets that they have acquired during their lifetime. And one of the land plots that you've mentioned, one of them in Chernivtsi region, I acquired it for construction purposes. So my first experience of acquiring a land plot while I was still living with my parents, I've gone through the procedure according to the law. So I have this experience of collecting documents that are necessary to acquire a land plot. So when I moved to Kyiv region, you understand that it's a huge difference, it's a huge distance, and I cannot use that land plot back in Chernivtsi region. So seeing information on the forums that in Kyiv region, it's possible to get a land plot that has been allocated, I have applied for the same procedure there. So I went to regional state administration on multiple occasions to write a statement, and they told me there were no land plots available for construction purposes. There were only land plots available to conduct some agricultural activities.
Have you sought rezoning of any of those land plots? Have you sought any recharacterization or rezoning of any of the land plots that were limited to plants and fruits and things of that sort?
Yes, thank you for the question. While going through the procedure of registration, I understood that was impossible to do because this land plot is located in the middle of the field. It's not located somewhere by the side of the road. It lies outside of the inhabited settlement. It's impossible to have any construction activities over there. It's just not feasible. But you can also see from the documents that my family runs some agricultural activities. They are quite successful in that. And the agricultural activities are actually what brought them the money that they have. I was thinking that maybe my mother would move to me and would deal with agriculture. And when I was turned down about a land plot for construction, I agreed to have a land plot where I could run some agricultural activities. It should also be mentioned that I have provided the Selection Commission with information about the value of this land plot because it appears that it has been a little bit distorted. In order to dispel the assumption of the value of this land plot, I have ordered expert assessment, and you can see it from the materials that I have provided to you. The value of this land plot in dollars is, one of them is $2 and the other one is $1,200. That's why I don't think it should cast any doubts or it should raise any questions for an outside observer or for any other people who will be assessing me as a candidate. Thank you.
What about the land plots specifically in Kiev? There's 3 land plots there, I understand. Have you estimated the value of those land plots as well?
Well, thank you for the question. These are exactly the land plots I've been talking about. I even didn't consider any appraisal of the land plots located in Khotyn district of Chernivtsi region. I've been now talking about the land plots which are located, well, not in Kyiv, but close to Kyiv. So it's one of them costs $200, the other one costs $1,200. And this appraisal of the land plots outside of Kyiv has been made by an independent expert who made the assessment following the formula, which is presupposed by the fund of State Property Fund, and it was developed through the USAID program because they developed software for such independent appraisals of the market value of land plots. So the appraisal was made using the software available on the website of the State Property Fund. And by the way, all the information about my land plots is available on the website. Thank you.
These would include the free land plots in Novy Petrivitsky, which has been described to me as one of the more attractive and fashionable parts of Kyiv. Is that correct, too?
Right, yeah. That's the land plot I've been talking about. 2 land plots located close to Kyiv. They are in the field for individual gardening and individual farming. They are located in Vyzhhorod district. And that's why probably somebody has thought that they are of great value, but they are not of great value. These are the land plots that have the target designation which cannot be changed. No rezoning can be made, as you asked about. And as far as the real value is concerned, I've indicated it in the right way. This land plot is located outside of an inhabited settlement. It's not in the areas that would make it really precious. I think that erroneous judgments have been made.
Okay, thank you very much. Let me move to my colleagues, Judge Mashenko.
Thank you. Pani Inno.
Inna, let's get back to your professional career path. I've counted that you have actually changed 14 positions in 6 different state institutions, state bodies. In case you are appointed a member of the HQCJ, this is going to be the 7th public authority. What is the area where you consider yourself to be an expert? What is the field of law, or what is the direction where you consider yourself to be an expert? Well, thank you for the question. The main thing that comes to my mind while answering this question is constitutionalism. I feel that I'm an expert in constitutional law because 2 of my papers have been dedicated to this. The PhD thesis and the doctoral thesis. And then when I worked in different state institutions, I always analyzed the acts of the state institutions, and thus I expanded my understanding of how the public machinery works, the state institutions work. And then when I worked within the Department of Administrative Law and Constitutional Law, I also had a good understanding of what is happening. Okay, so expert in constitutional law. What about constitutionalism and being an expert in constitutional law? How does it correlate with selection of judges? Well, this is the general understanding, and then it came to the implementation of constitutional principles in all the state authorities. I have been thinking whether it's good or bad that I used to work in many positions in different state institutions. For me, this is good, because this means different areas of expertise and experience of working in different teams. This stands also for assessment of the mistakes of progress and achievements of the chiefs of those authorities. And this is the experience of working in teams. And I think that experience of working in joint bodies like the Central Election Commission and the National Agency for Corruption Prevention, this is something that is going to be of use for me when if I become a member of the HQCJ. And in what bodies did you have anything to do with selection of staff? Did you make selection in any of your bodies where you worked? Yes. Well, I was not a member of the Selection Commission. I don't have an experience like that. At least I don't have a document that I've been doing this. But since in the National Agency for Corruption Prevention, I started working from the beginning of operation of this authority. I actually had to deal with all the selection procedures because the staff of the national agency are the staff according to the law on the civil service, and all the processes have to be meeting the criteria of legislation, and these people were to be men of integrity, so we paid a lot of attention to integrity criteria. Also, we worked with integrity issues within the Central Election Commission because we needed to check whether the candidate really is a decent candidate. And the latest experience is the experience in the Secretariat of the Ombudsman of the Commissioner, because I supervised the work of 4 structural units and there was some staff turnover. And the people who came to work there had to undergo a certain selection procedure. And of course, I was present at this selection for me to understand what our candidates are like. Addressing your motivation letter. Here is your answer to question 8. Please tell about your vision of the future of the Ukrainian judiciary. You have indicated rather clearly that there should be 3 stages the HQCJ should pass. And I have some questions concerning the second stage. Let me quote, the second stage should be provision of the adequate level of coordination and strategic planning of the process of reforming within the system of judicial self-governance and judicial governance bodies. What do you mean by this? Well, coordination and cooperation. I mean that, but just there came a message popped up that connection is bad. I've heard you, but just I've got the message on my computer. Okay, please give your answer. So here is an example. There should be some coordination with the High Council of Justice as far as the commencement of the selection procedure and the deadline of the procedure is concerned, for the High Council of Justice to also be able to plan its work. Because when recommendations are delivered by the HQCJ for appointment, the High Council of Justice should be able to immediately consider the recommendations and to submit the applications to the president. We are all talking about abbreviation or shortening of the procedures. So probably the HQCJ should also have some deadlines for the consideration of different issues. Maybe we could set by a certain act at the level of some coordination meetings, you could agree that we need to coordinate your activity. And we should also work at trainings. I think that trainings, due to lack of staff, and due to the fact that judges need to be appointed to appellate courts, and this should be done immediately, this is one of the most important things. So taking all this into account, we could shorten the period of trainings for judges. In particular, for assistant judges, this could be up to 2 weeks, and for judicial candidates and for other lawyers, it could be up to 2 months. We could agree on the very program, on the curriculum of this training, and this all requires coordination, cooperation, which would be quick and efficient. That's what I meant by this. Okay, thank you for the answer. It's clear. Let me give the floor to my colleagues. Serhii, the floor is yours. Do you have any questions? Yes, sure. Inna, we have already listened to a couple of your answers related to different positions of yours and your huge experience. And let me clarify one thing with you. What do you think? What previous position has given the best experience to you for holding one of the key positions in the judiciary of Ukraine, which the member of the HQCJ is, and why? Thank you for the question. My answer would be that this was the work in the National Anti-Corruption or National Agency for Corruption Prevention. Because there I learned how to assess the integrity criteria. The work of the Qualification Commission of Judges actually lies in assessing judicial candidates in terms of integrity and professional competence. So the issue of integrity is something where I have huge experience. I went to Romania to get this experience, and I went to other countries, so I have huge experience in this field. Clear, Inna, please, could you tell us in detail, how did you assess integrity criteria while assessing candidates? Well, the key thing here is monitoring of the way of living standard. This is important, and you really need to assess this under any circumstances. Of course, you also need to make some analysis of the declaration, and also you need to assess the declaration of family ties, family contacts, the clarity and accuracy of information provision. If we speak about judicial candidates, we should also assess the declaration of integrity, declaration of judicial integrity. And again, if we speak about a judge, we have to assess the dossier, judicial file, and we should assess all the documents and all the information available in the dossier, all the information obtained from Public Integrity Council and from law enforcement bodies. Thank you. Please tell us, what is your assessment of the current qualification assessment procedure? And does it need to be reformed or changed, and what kind of changes should those be? Well, the current judicial selection procedure, thank you for the question. I think that the current selection procedure, the same as the processes related to qualification assessment, are regulated rather well at a high level. All these processes were taking place after amendments were made into the Constitution of Ukraine in 2016, when the reform started, the reform of the judiciary of Ukraine. We understand that many things have already been done. As far as the exam is concerned, I would not change anything. As far as qualification assessment is concerned, I have some suggestions concerning reduced timeline. I've indicated, and I think that it's not only me, everybody is talking about shortage of staff, of judges. So I think that we need to reduce the timeline for document submission from 30 days to 15 days, and the submission procedure should be online, should be electronic, and documents should be registered automatically. Also, we need to set the periods of preparation for the exams of no more than 30 days, starting with the date when the sample of the practical task and the tests are published. You should also reduce the training for judges up to 2 months, no more, as I've already mentioned. And this work related to coordination of the processes with the high qualification of judges is concerned. It should also be done because the procedure actually depends not just the procedure of completion depends not only on the HQCJ, but on the High Council of Justice and on the President of Ukraine. It depends on when he issues a decree, so there should be good coordination. And I think that cooperation with Public Integrity Council should be transferred into the documentary form only. It may look as follows. The HQCJ appoints or schedules the qualification assessment for the candidate, then Public Integrity Council gets the information about the surname, collects information, sends the opinion to the HQCJ. Their panel of the HQCJ takes into account this information about the candidate, and if necessary, asks the questions during the interview, then passes the decision to recommend or not to recommend. And participation of a Public Integrity Council in this meeting is not obligatory. And in case there is a need to make an opinion, there is a plenary session of the HQCJ, and again, members of the Public Integrity Council are not to be present on a mandatory basis, because so far it's mandatory. It's better for the Public Integrity Council to have more time to collect materials, but to save time as far as their participation in the meeting is concerned. And it would be all transparent, all reflected in documents, and you could actually provide the evidence at any point of time. I don't have any other questions, so Inna, I have some questions. Taking into account your huge experience of working, in particular in the National Agency for Corruption Prevention, you are, I think, proud of. It should be noted that now there are some serious criteria that actually help support the integrity status of candidates. These are e-declarations, control over expenses, and declaration of family context, as you have mentioned. Please do tell us, from the point of view of your professional background of working in the National Agency for Corruption Prevention, what would it be that you would suggest? Something new that doesn't exist as yet, but that would be efficient for identifying candidates who are not men of integrity, to prevent them from getting into the judiciary. Just one proposal, one suggestion. Thank you for the question. In this specific case, I would say that this is exactly the field where everything is there in the legislation, and it's only the issue of enforcement. And the proposal would be for officials to clearly and responsibly use the mechanisms available in the law, and the mechanisms all responsible bodies, including law enforcement bodies, NABU and ACP have, and the Ministry of Internal Affairs. If all of them use all the tools available to identify some indicators of lack of integrity, that will be more than enough. Thank you, Inna. Clear. And here is another small question. While selecting candidates, well, in this process, we also have NABU and ACP candidates, and they have also made some suggestions. And one of the professionals has made a remark that it would be expedient, in his opinion, to use polygraph testing during the interview, during preliminary assessment, and before further appointment of the candidate to find out what his level of psychological resilience and integrity is. And the main thing is to identify whether he is not going to change in the future, because he may be honest and man of integrity now, but he will become man with lack of integrity in 3 years. So what about the possibility of using polygraph testing, and whether it is ethical, whether it is expedient, and will this not be a tool used to exert pressure on judges and breach the independence of judges? Thank you for the question. Well, it has just occurred to me that I had a case in the Secretariat of the Commission on Human Rights. We were addressed with the suggestion that really this polygraph testing should be a component of selection procedures for the candidates to the state guard service affiliated with the president of Ukraine. Yes, this is the Department of the State Guard Service. Yes, it's a difficult name. And this body has a lot of different functions that I have mixed the name. So we were researching this issue concerning the legitimacy of using polygraph testing, and we actually studied the limit, the boundary of interference into private life of a person. As for me, in case there is a clear understanding concerning the reliability of data, and if this polygraph testing is certified, this is one thing. But now, not a single polygraph in Ukraine would perform following some standards. Well, not standards, but following some documents, on the basis of some documents. So back then, we drew a conclusion that it's not possible as yet from the legislative point of view. Well, thinking whether it's necessary or not, taking into account the fact that the HQCJ takes into account the criteria of psychological testing developed, as far as I know, using international experts on these matters. So I think that the indicators, the signs could be seen even without this polygraph testing. So you think that it's an extra thing, it's not necessary. I don't think that we shouldn't be using it at all, maybe somewhere in the future when we have a clear reliability of this data. But so far, we are not sure about the reliability of data, so I think that this is interference into personal and private life of a person.
I hope you don't mind I call you Inna, of Inna. Do I say that correctly? Yes.
Yes,
In
please.
your opening statement, you said, and you have said it many times, it's all about enforcement. Yes? So, and if I translate that for myself, it means that you may have the most fantastic rules in the world, but if you don't enforce the rules, there will be no change. Is that what you wanted to say?
Thank you for the question. Yes, that's exactly what I meant when talking about the judiciary, when talking about the judicial reform.
Okay, thank you. Yes, you say about yourself in your motivation letter Yeah, I'm sorry I interrupted you, but in order that we have a few answers to a number of questions, because you're quite extensive in your answers, so I tried to limit it, and I'm sorry about that. You say about yourself that you are someone who has zero tolerance to injustice, discrimination, and corruption. That's correct, huh?
Right.
And can you please tell us how this is shown that this is so? Because reading all the information, I have not seen any evidence of that.
Thank you for the question. Well, when I was writing my motivational letter, I was trying to be absolutely frank and sincere and be guided by my feelings.
Okay, I understand that.
And these are the criteria which are difficult to confirm or to prove. It's easier, much easier to provide the evidence and of some violations, breaches of the law. But when you speak about positive things, the best confirmation or the best opportunity is, of course, when the third parties speak about that.
No, I understand that. You also say that.
I just meant that there is some fight against corruption. There is lack of perception of corrupt behavior, and my life long I was trying to help people to be just and fair.
Okay. You also say that you are someone who strives for systematic changes. That's correct, isn't it? Yes?
Right.
Well, let's say you are in the HQCJ, you're appointed, and there is news in the press about a possible corruption case of a judge. You are someone who has zero tolerance on corruption. You are someone who's striving for change. You are someone who believes that enforcement should take place. What will you do?
Well, if such news appears in press, most probably I will first of all discuss this issue with my colleagues during a meeting. And we will discuss whether it's necessary to address respective bodies to bring this person to account for misconduct, misdemeanor. And the High Council of Justice is the body we should address in such cases. So I think that there are a lot of tools to really study the issue in depth and to pass the respective decision. Thank you.
But in fact, it means that you are not doing anything, isn't it? Because it means that the judge, where there are allegations of corruption, can just continue to be a judge. Because if you are someone who strives to take active, you believe in zero tolerance, you believe in enforcement, you believe in systematic changes, the action you are taking is resulting that the judge will remain in its position and that the people who go to this judge for a judgment will see that this judge is still delivering judgment and still doing what the judge is doing. And that doesn't build trust, does it? To the people who are looking for justice.
Well, if I get such news from press, so the first body that needs to respond to that is the National Agency for Corruption Prevention, which takes information from press and which has the mandate to start a full-scale inspection on the basis of this information. As far as the HQCJ is concerned, we don't have this mandate. I'm not ready to answer the question whether we can actually act on the basis of the information from the press. I mean, whether we can start qualification assessment of this judge on that basis.
Yes.
As far as
this-
bringing to account is concerned, so this is the mandate of the High Council of Justice.
No, I understand that. The point is that when I listen to what you say, and if I read your motivation letter, what I see is that you say that you are looking for systematic changes. But in fact, what you do is that you're looking for administrative solutions. And administrative solutions, they have one proof in the past that they often do not work. In order to raise the level of trust, something needs to happen. And my question then to you is, let's say that you would have all the powers in the world. What would you do?
Thank you for the question. Well, in case I'm appointed a member of the HQCJ, first of all, I will need to hold this qualification assessment of the judges who have not yet passed qualification assessment, because most probably they may be taking some illegal actions. This may be the case, but the ones who have already been selected through the new selection procedure with the qualification assessment, who have passed it, would actually be supposed to raise the level of trust in the judiciary. And as far as I know...
That's not my question. My question is, let's say there is an article in the newspaper about a judge connected to corruption. Let's say you are in a position of power, let's say the HQCJ. Let's say that you have all the powers in the world. You say that you are innovative, you are changing, and you want something to be done. You also say that enforcement is the only way. What will you do?
Thank you for the question. I've got it. Well, anyway, the HQCJ doesn't have the mandate, but for qualification assessment, the HQCJ doesn't have any other mechanisms and tools. I cannot exceed the mandate as a member of the HQCJ. We do have NABU, we have the National Agency for Corruption Prevention, and if a judge is undergoing qualification assessment, well, then yes, of course, we could take this into account. In other cases, I cannot do anything. Thank you for the question.
But that would mean that if you would be in a position of power and you would be confronted with corruption, you would do what you just said, that it's nothing. And that would not result, because what you also said is that there is a war going on regarding democracy. And part of democracy is not only voting for people, it's also making sure that there's a rule of law. And there is no rule of law if the people in power don't take action against corruption, isn't it? So the question is again, what would you do if you had all the powers of the world?
Well, as far as this specific case is concerned, if such a candidate is undergoing qualification assessment, he will definitely not pass it. And every official should anyway work within his or her mandate. You have given the example when I actually still function as a member of the HQCJ, and I cannot exceed my mandate. I cannot say that I have all the power of the world. And if this candidate is undergoing qualification assessment, of course, he will not pass.
Thank you.
In all the other aspects, the other respective bodies should come into play.
Запитання мого колеги стосується
Inna, the question of my colleague is related to the theoretical, hypothetical situation when the HQCJ has all the powers of the world. Let's imagine that you, as a member of the HQCJ, have all the powers in the world as a result of some amendments introduced to the profile law. That's what my colleague is asking. What would be your specific actions if you really have all the mandate, all the powers? Hypothetical situation. Just imagine that it's not the HQCJ has joined the High Council of Justice, but vice versa, and the High Council of Justice has become a department of the HQCJ. Well, no doubt such judge must be dismissed from his position. After any notification in press, in mass media? No. After the inspection is made, after facts are checked, there should be a talk with him for him to be able to provide his answers and his evidence, his explanations, because not a single decision can be passed without this by any single state body. There must be all the procedural elements followed, and there should be assessment, examination based on the facts, it should all depend on the gravity of the crime. But currently, the example you have given, well, I just clearly understand what procedure we have currently got. We have NABU, we have an ACP, criminal proceedings can be initiated, and it was within criminal proceedings that everything should be followed. Just to imagine this as a hypothetical situation with this High Council of Justice, well, we should see the procedure then. The main thing is that the crime or the offense should be assessed. The candidate or the judge should be given an opportunity to explain things, and we need to follow the procedure and then pass the decision, because then the decision can be appealed in court. And the experience of our previous HQCJ shows that not that many decisions were appealed, but the decisions that were appealed were largely not cancelled. So we should work better, not worse. So that's why we should be working following the procedure. Before I give the floor to Tadzajache, my colleague, let me have a quick question. And please, Inna, I would ask you to very briefly answer this question. In your motivation letter, within the third stage of the development of the work of the HQCJ, you indicate that the HQCJ will implement the best world practices in its activity. Could you please mention a country and a practice that will be implemented? Again, when I was writing my motivation letter in this paragraph, to be more specific, I just meant that we need to make a research, to analyze and to implement the practice. I don't have ready-made best practices. I've just indicated that these procedural issues and the regulatory norms, the legislation, are at a rather high level. Probably our legislation in this respect is among the best ones, even within the European standards, or if compared with the European standards. But there is always room for perfection. We need to communicate with our foreign colleagues to really study our best practices, their best practices, and to strike the right balance, because we have a lot of procedures that are really required, and now they have been adopted as critically important. Thank you, Inna. I've got your answer.
Thank you again, Ms. Bernaziuk. I'm sorry to focus on so many financial issues, but I feel they're important here. And we sent a number of questions to you last year, and you provided some very thorough answers to those questions that we had raised. But there were two things that I didn't feel were answered fully, and I guess I'd like to ask you those again so that we can review those, I think, with the benefit of the fullest possible knowledge here. Explaining your wealth as of 2016, you note that the fundamental source of its origin was your family's salary, and especially the sale of an apartment in 2008 by your husband. I would ask you, number one, what were the sources of funds to purchase that apartment? And secondly, you indicate that in 2007 you acquired an apartment in Kyiv. My second question is, what were the source of funds for the purchase of that apartment? Your salaries and finances as of that time were relatively modest compared to later on, but To me, those questions are pretty critical questions. What was the source of your funding of the apartments? I know there was a loan you mentioned, but that didn't come to afterwards. What was the source of funding for the purchase of those 2 apartments? Thank you.
Thank you for the question. I'll try to answer the questions in the order you have asked them. The apartment in Kyiv was purchased before, but as far as 2016 is concerned, the major savings originated from my salary and the salary of my husband over the recent 5 years before 2016, before the date when we acquired this apartment I'm going to speak about later. The savings left after the acquisition of the apartment were deposited in banks, and the Selection Commission has been provided with the documents and with absolutely all the data reflected there. As far as the sources of assets for the acquisition of the apartment where I now live, which was the main one and which was bought by our family as the main apartment for our accommodation, well, really, it's an expensive apartment. It was difficult to purchase it because of the price. That's why we registered 2 credits. We took 2 credits, one of them for $150,000, the other one for $100,000. And our salaries, I mean, my salary and my husband's salaries were always high, and we indicated this in our declarations, and we also provided some certificates from the pension fund to the Selection Commission. And as far as the apartment sold, it was sold at $189,000, if I'm not mistaken. It was actually earned, the money earned by my husband before our family was registered. Because he worked for 5 years in a commercial bank, and there he earned money for this apartment. So actually 2 credits, $100,000, $150,000, and the apartment which was sold at the price of almost $190,000, and our salaries, annual salaries that were transparent and well declared, and which were rather high. So these are all the components, all the sources of assets for the purchase of this apartment. Thank you.
Thank you.
No more questions?
No more questions.
Okay. Finally, the word goes to you, Ted. Sorry for interrupting. Finally, it's your turn. Floor is all yours, please.
Yes, Ms. Bernaziuk. You know, I think very well, as many people interested in this competition know, that there are approximately 2,200 or more vacancies now in the courts, that there are over 2,000 candidates, judges, existing judges, who need to be requalified with a qualification assessment. And I think you would agree with me and acknowledge that the bulk of these judicial reviews affect people who are seeking to be judges or who are judges in the courts of first instance. Now, in my country, we call those courts the people's courts. And we do so because the judges of the courts of first instance hear all kinds of cases, all kinds of human disputes, matrimonial problems, problems with property, properties with criminal law, etc., etc. I have looked very carefully at your work experience, and I don't see any suggestion that you appeared in court or that you have any association with judges of first instance. So you will be responsible to assess these candidates as a member of the High Qualification Commission. What can you point to in your experience that would qualify you to do that?
Thank you for the question. Well, first of all, as I've already mentioned, while working at the tax inspectorate, I was representing the interests of the state in courts. And at that time, I got to the bottom of things. I discovered all the procedures. I learned all the rules, norms, and relevant regulations. Frankly speaking, you've already asked me about my husband, and since he also went through the qualification assessment, I also tried to learn a little bit about the process, and I clearly understand what the criteria are and how the judges should perform their duties. As far as I understand, the procedure of qualification assessment, 90% has been completed, and it's only the final stage of the interview that is left. In all of the processes, we need to be careful when we analyze the decisions and judgments made by judges, because we understand that judges are independent when administering justice. So we have to be very careful about assessing their decisions. And the other thing that is worth mentioning, since we are a collegial body and 8 members of the High Qualifications Commission will be representatives of judges, and should I not have a profound understanding of some processes, I believe that the colleagues will be able to help me with that. Thank you.
Thank you for your answer. You spoke very briefly about a proposal that you have to assist the High Qualification Commission of Judges dealing with the National School of Judges and the training of judges. And I was quite surprised by your suggestion, if I understood it correctly, that you would propose to reduce the training period for judges to 2 months, and even far less than that for assistant judges. Now, I have 2 or 3 questions related to the education of judges, because, of course, that is very important to their ability to function properly in the courts, particularly in the courts of first instance. So, do you know how long the current study at the National School of Justice is for judge applicants?
Thank you for the question. Currently, it lasts for 12 months. I was introducing this proposal for the future members of HQCJ. I think it's a debatable question. When I was putting forward this idea, my thinking was that we need to shorten the duration of the process, and I think that's one of the areas where we can shorten the procedures. But I believe that the candidate judges, first of all, there are some requirements for candidate judges. They already have to be lawyers and experienced lawyers at that. They need to have some experience already. Self-training is also essential, and if we develop the curricula in a proper way, so that after the candidates, after passing specific tests, if the program is intensely packed, I think they can manage.
All right. Let me ask you a follow-up question in this area then. Have you studied the curriculum of the National School of Judges?
Frankly speaking, I haven't. I didn't have enough time.
All right. My question was going to be, if the current curriculum is 12 months long, what would you propose to eliminate in order to educate judges for 2 months? But of course, that question is not fair to you if you have not studied the curriculum. All right. Thank you, Mr. Chairman. Those are my questions.
Thank you.
Пані Інно,
Inna, if I understand correctly, we have no more questions for the candidate. Well, the commission now gives you an opportunity to conclude the interview. In case you'd like to add something, if there are any clarifications to your previous answers, you now have this opportunity of up to 3 minutes for concluding remarks. You're welcome. Thank you. Thank you for the opportunity to be a participant of the stage 2 of the selection. Thank you for your questions. Thank you for your time. Thank you for the time you have spent studying my autobiography and the other documents I have provided. With regards to anything I'd like to add, well, I tried to tell you more about my previous positions to explain how relevant my experience in the field of law was, but it appears that I wasn't always successful in doing that. But nevertheless, I believe that I've mentioned everything that was of importance. That's why I don't want to add anything at this moment. Thank you. Thank you for participation, Inna. That's all. That's the end of the interview. Best of luck to you. Goodbye. Bye-bye.